Who are you? And where are you going? What do you want?
Hello and welcome to Trust and Estates Weekly. I'm your host, Kevin Bemmel, and we're here every Monday at 10 a.m. Pacific time to talk about all those matters related to estate planning as well as trust and estate administration, both from the standpoint of us as individuals who need to take care of this for our own well-being, as well as professionals. So, today, my topic a little bit different. So the probate courts, at least here in California, are broken. And I've unfortunately gotten to see this firsthand this year. And so I wanted to talk about what some of the problems are and give some thoughts on what needs to be done to fix them, and perhaps spark a discussion as to what needs to be done to improve the system here in California. So let me say from the beginning that all my years in the military, most of the commanding officers that I had, and they were not interested in hearing the problems that were going on in their units unless they came with a solution, or at least a proposal on how it might be solved. And I think that's a really good perspective for us to take on these kinds of issues. It's all good and well to complain about them, but the complaining doesn't do anything except for upset us, upset other people, and in many ways make the problems worse. So as much as this is identifying issues that need to be addressed, it's really more about what are the things that we can do. So I've just got a short list of items here, 6 items that I want to talk about. And if you're watching this live, I encourage you to put your comments in the various chat functions. They do aggregate here on this side of my Restream screen, and so if someone does make a comment, I will take a moment to address it. Otherwise, if you're watching this not live, so nonetheless, feel free, please, to comment on it or contact me with it, because I think this is an important issue for those of us involved in this area, and it's not going to get better through neglect. That's for sure. So first off, and this is an issue that I've talked about before. It wasn't identified by me. It was first brought to my attention by my friend Josh Yeager, who's a trust and estate lawyer and administrator based in Santa Barbara. And that is, in California, there were just flat out too few administrators. So Josh tells me there's roughly 6,000 lawyers who are involved in trusts and probates in California, many of whom are on the older side of life, and so the profession is not attracting, or not the profession, but this area of law practice is not attracting younger people the way it used to. Now, I do a lot of outreach to trust and probate attorneys. Through LinkedIn, I contact 20 every weekday, basically, by way of establishing professional relationships. And I will say that at least half of them are, I think, more toward my age, late 50s into their 60s and maybe older. And very few seem to be in the early part of their career, in their late 20s or early 30s. Even the younger ones seem to already be in their late 30s and 40s. So I don't know why that is. If you're an attorney and you have some thoughts on that, I would love to hear it. From the perception of, or from the perspective of what I do, which I'm a licensed professional fiduciary here in California. So my license number is 1341. Now, I did some research before the show. As of 2021, there were only 1,250 licensed professional fiduciaries in California. Now, I got my license the following year in 2022. So it was about 18 months after that figure came out. So, do the math. There were 90 in 18 months, which is roughly 5 a month. So that works out to be about 60 per year. So since 2022, we've maybe had another 100 or 120 join the ranks if that pace holds true. So we may be somewhere around 1,450 to 1,500 professional fiduciaries. Now, here's the rub. In 2021, when there were 1,250, only 825 were active. So 2/3 roughly. So let's take the more optimistic figure, 1,500, and if that holds true, the 2/3. So of the 1,500, somewhere between 1,100 and 1,200 are practicing, which isn't a lot. That stacks up against what Josh told me. I think was $800 trillion in wealth that's going to transfer here in California over the next 10 to 15 years. So if we have somewhere around 7 to maybe 8,000 professionals to handle that, just kind of do the math. That's hundreds of millions of dollars, I think, that each one would have to administrate. And that's a lot, so we really, in the end, we just have too few administrators. Now, I think like I said, I can't comment on the attorney side of the equation. I'm not an attorney, and I haven't spoken to attorneys about this. So I'm going to focus on the professional fiduciary side. So as of this year, the license fees for professional fiduciaries quadrupled. So when I got my license in 2022, the fee was $650 for 2 years. When I renewed it this year, the fee had risen to $1,300 per year. Now, I get it. The state of California wants to generate revenue to cover the costs of the program. But the fact of the matter is, for someone who's starting out, to pay $1,300 a year for a license fee, that's far and away the highest license fee here in California. By contrast, a real estate license is, I think, around $400 or $500. Even an appraisal license, I think, is $800, something around there. A real estate appraisal license. So clearly, the fee is much too high, and the state of California would be far better off encouraging more people to become licensed professional fiduciaries and generate revenue through volume rather than through a price increase. That's number one. Number two, I was at a networking event a week ago today, and this was a group of primarily real estate professionals, but the sophisticated real estate professionals. It was sponsored by George Smith Partners, which is now part of Axis. I've known the president of George Smith Partners, Steve Brand, for decades. This is one of the premier real estate finance organizations in the country, and they do very sophisticated real estate financing, all of a commercial nature. And as I talk to people there, none of them knew that there was such a thing as a licensed professional fiduciary. They all understood, at least in a general way, the need for trusts and estates to be administrated, but they didn't know that there was such a profession as the one, or such a license as the one I had. And in fact, one of the people I spoke to thought it would be an ideal profession for his brother, who was looking for something else to do because he didn't like what he was currently involved in professionally. So I think too that there is woefully insufficient knowledge that this profession exists. Having said that, and this is an issue that I identified in talking with another friend of mine, Kaya Johnson, who coincidentally is also a Santa Barbara-based administrator. So Kaya and I think that a very large percentage of licensed fiduciaries here in California actually come out of the healthcare arena, and their primary interest is in acting as conservators and guardians, and they're involved more on the personal care or the health care of their clients. And so they don't have a particularly sophisticated background in financial management of any kind. So look, anybody can pay bills. That's not so complicated. But when it comes to the more complex aspects of trust and estate administration, someone with a healthcare background is going to be challenged. I'm not saying that they can't do it, but they probably don't have a lot of experience in that area, and so it's more difficult for them. They can't work as efficiently, and so again, that I don't want to say it exacerbates the shortage. It doesn't, but they can't handle as many cases as they might otherwise want to until they get up to speed on the financial side of things. So I think there needs to be some kind of initiative taken by either PFAC, which is the Professional Fiduciaries Association of California, to publicize to other types of professionals, maybe bookkeepers, accountants, non-CPA accountants, and other people who have a financial background to consider becoming a professional fiduciary. So I know I have a colleague here in Los Angeles, and I'm going up on his name. We spoke last time, I think about 7-8 months ago. He was actually an accountant working for Sony Pictures, and he decided that it was kind of a dead end with what was going on in the film business during COVID, and he switched over to become a licensed professional fiduciary, and he has a great practice here in LA, and as well he should. The kind of financial issues that he's dealing with at a huge company like Sony Entertainment are a great background for making the shift into probate and trust administration. Now, he may not know the legal issues very well, but because of his background, I'm sure he learned them quite quickly, and that's what has allowed him to be successful. So this is, too few administrators is the problem. I do think that dramatically increasing the awareness and the outreach of the professional fiduciary license would be a step in the right direction of solving that. Next, there is a misalignment of priorities. Now, this sort of meshes with another problem, which is there are too few judges in the probate court. So what I see in probate courts today is a priority on clearing one's calendar. So if I were a judge, I'm going to have a calendar basically every hour or every hour and a half, a calendar of cases that I need to address. And that calendar can contain easily 30 or more cases. Okay, so let's say I've got an 8:30 calendar, and I've got another one at 9:30, and on the 8:30 calendar, I have 30 cases that I have to address. Well, the fact of the matter is, rarely are all 30 cases ready to actually appear and in front of me. But it may be a third of them do, 10 of them do. So in the hour-long period that I have as a judge to deal with that calendar, my clerk is likely to take anywhere between 15 minutes and 30 minutes calling the calendar, which means essentially taking roll, making sure that the parties who are supposed to be there for a hearing are in fact there. That's number one. And number two, dealing with the cases that don't actually need to be heard, either because there is a reason up front for them to be continued to another date, or one of the parties at the calling of the calendar it wants to request a continuance. That's number two. Or number three, there has already been a decision made by the judge, either to, if it's a petition, for example, go ahead and grant the petition without a hearing, or deny the petition without a hearing, or continue the hearing because the judge feels, advisedly or not, that there's something missing, and so it's not worthwhile to have a hearing on a particular matter because there are things missing. Perhaps the lawyers were told they were missing and they didn't get them into the court soon enough in order for the judge to be able to review them. Or it may just be that there's another issue which I'm going to deal with in a few minutes. But let's say even 2/3 of the 30 cases are dealt with by the clerk. Okay, and by the way, the more cases that are dealt with by the clerk, the more time it takes for the clerk to call and set the calendar. Okay, but let's be really generous and say that those 20 cases are dealt with in 20 minutes. Very unlikely, but let's say that they are. That leaves 10 cases to be dealt with in 40 minutes, or on average, 4 minutes per case. Okay. Now, I'm sure you can appreciate this is, in the vast majority of cases, inadequate time to deal with any kind of substantive issue. And what I find is the judges are under, or at least feel they're under, tremendous pressure to clear their calendar. And so they really rush through cases. And if there's any kind of dispute, the judge may hear literally a minute or two from each lawyer, but that's it. And then the judge is making a decision. And oftentimes that decision is to postpone deciding on the matter while the parties either confer directly if there's some kind of dispute, or while there's additional information filed with the court, so that the issue the judge is concerned about can be clarified. Or I watched one case a couple of weeks ago where the judge basically is trying to convince the lawyer to file the matter in a different court up in Northern California, even though the lawyer clearly believes that there is good reason for it to be heard in the Los Angeles court. And so there's a misalignment of priorities there, that in part because there's too few judges and they feel compelled to get through their calendar as opposed to make progress on cases, these matters get continued and continued and continued, and they take much longer to deal with than, frankly, I think they ought to. The reality is, just to give the parties to a case, even if, by the way, even if they're not contested. So I've been in hearings where we were not contested. There was no other party disputing what we were saying. It's the judge had questions, and in one case, she wouldn't give us literally no time at all to give her an explanation. And in another case, she gave us 4 minutes to, try and explain uh, what it was that she said she didn't understand. In the latter case, we at least made some progress because she agreed to take it under advisement and to issue an opinion later that day. Now, because of some problems with the court system, we didn't actually get a decision until almost a week later. That's not necessarily the judge's fault, but the amount of time that she gave us to make our argument and flesh out the case was minimal at best. And the decision she finally rendered was kind of a Solomon decision. It was a split the baby decision, and there was no reason for that. If she had been, now in this case, she also was not properly prepared. She hadn't read the pleadings in advance, which is also a problem that I'll get to in a minute. But it very, very frustrating because we're trying to make progress on a case, and really the judge is fighting us on that, and not for any good reason, in terms of the real purpose of the probate court, which is to protect the beneficiaries and make sure that they're being treated not only in accordance with the law, but in an ethical and sound fiduciary way as well. So very, very frustrating situation. Now, the cases that I've just mentioned, they dovetail with the next problem with probate courts. And that is, in my experience with the judges, they lack the knowledge of the law and expertise necessary to really understand anything other than the real basics of the kinds of issues that they're confronted with in the probate court. So if it's a very simple matter, maybe there's a house and a couple of bank accounts or whatever, seems like not a big deal. But the minute any kind of complexity enters into it, so maybe there's the estate owns a business that needs to be run, maybe there are disputes between heirs, maybe there are complex real estate situations where there's real estate entities, there's loans on the real estate, and the loans may not necessarily be only against the real estate. There may be personal guarantees on the loans, and you've got a lender that it has called a loan because now the personal guarantor is now the decedent. They're dead, right? That gives them the authority to call the loan and require that it be paid off. Those kinds of complexity, in my experience, seem to be beyond the expertise of the judges that I've had to deal with. And in another case, again, this is a large, complex estate where the estate is subject to estate taxation, and so we need to have valuations of assets that will be credible for the IRS. And so we've applied to have the appraisal by the probate referee waived because the probate referee does not have the proper credentials that the IRS requires for evaluation being done for estate tax purposes. And we are, as a matter of law, when I say we, I mean me as the administrator, and then the attorney that is representing me to the court, as well as the beneficiaries, although they don't, as for those of you who saw my episode on the power relationships, the beneficiaries don't actually have any standing in the court per se. However, I make it a practice to communicate frequently with beneficiaries to an estate and make sure they understand what's happening, address their questions, and see to it that they're fully versed in the progress that a case is making. So that's when I say we, I mean, the group of us who have an interest in seeing the administration process conducted in a timely manner. So we have a situation where we all not only agree that the probate referee's appraisal is of no value to the estate, but we have a statutory basis for applying for a waiver, which means that as a matter of law, we can apply for a waiver. Now, we've been dealing with this issue in this one particular case for months now. And the judge handling the matter actually said from the bench, she's never seen a waiver. And so she's skeptical of it. And while she hasn't made a decision, because the hearing isn't until the hearing kept getting put off. The hearing finally got put off until the beginning of next month. She said we should, take a clue from that as to how she's likely to rule. So essentially what this judge is saying is, I'm going to require you to spend $40,000 or $50,000 getting the appraisal by the probate referee, even though, number one, it has no value to the estate at all. Number two, it will in fact damage the estate because it will defray the assets of the estate by that amount. Okay. And number three, this is a complex estate with a lot of highly skilled, highly experienced individuals involved. And so the idea that an individual, in this case, the probate referee, who does not have anything like the credentials and the experience and the skill that the people who are already involved, is somehow going to add some value to the proceedings is quite frankly ludicrous. So the problem really comes down to, this judge is relatively new to the bench, but by the same token lacks what I would call the humility that the judge ought to have by being new to the bench. And so it's causing a lot of problems. It's caused the estate to have to bear additional costs for legal fees, etc., while we bolster our argument for having this appraisal by the probate referee waived. And it's not just the money, by the way. While an appraisal by a probate referee by statute has to be completed in 90 days, the probate referee has the ability to apply for an extension. And for an estate of the size that we're dealing with here, it wouldn't be unusual at all for the probate referee to take 5 to 6 months to get that appraisal out, which basically means the administration of the estate would be halted for 5 to 6 months while the probate referee does his thing. And there's no reason for this, especially since the estate owes estate taxes. So we'll be accruing interest on the taxes owed because the estate doesn't have the liquidity necessary to pay the taxes. And so in addition to having to pay the probate referee unnecessarily, because we're going to have to turn around and hire a qualified appraiser to do the appraisals again, we'll also be paying additional interest to the IRS while we wait for the probate referee to do his thing, so that we can then sell the assets that we need to sell in order to pay the estate taxes. So all of this comes out of the lack of knowledge of the law and the lack of expertise on the part of this particular judge. And if this were an isolated case, that would be one thing, but it's not. Unfortunately, there's been a big turnover in judges, at least here in the Superior Court in Los Angeles. I think that's generally speaking true throughout California. And the new judges just do not have the legal knowledge and expertise that the previous generation of judges had. And so how do we solve this problem? So part of the problem is structural, as I mentioned earlier, about the fact that there's only about 6,000 trust and estate attorneys here in California, and they're getting older. So that would typically be where the best judges would come. In other words, people who have been practicing in this area as lawyers for a couple of decades at least, and so have dealt with these issues day in and day out. They understand them. They have a very thorough grounding in them. And so when they step into the role of judge, they're able to understand matters quickly, and they don't have to either put matters off in order to clear their calendar, or put matters off in order to gather more information. And as well, when they read pleadings, they can quickly absorb what they're saying because they've written hundreds of them in their careers before. So that would be historically, that's where judges came from. These days, the judges in the probate court tend to come from other areas of the court, and so they have little, if any, background in probate matters, and they're learning it somewhat on the fly. And that's a very inefficient way to handle the training, if you will, of judges. So I think we need to go back to looking at the qualifications of judges in a critical way. Now, that is somewhat difficult here in California because we elect judges, and the vast majority of voters, I think, don't even vote in these races. And that's a big mistake. So I think we as citizens need to do two things. One is we need to commit to doing the research necessary in order to understand the qualifications of judges, and excuse me, encourage our friends to do the same thing. I've been doing this now for the last, 6, 7, 8 elections, I think. And there are websites, they're very easy to find. You just search a judicial candidate's name, and you'll find the website. Once you found the website, you can just plug the name of each candidate in and get some basic information about them. Usually you'll get kind of their CV or their resume. You'll see who's endorsing them. Often, some of these judges now have their own websites, and so you can also get a sense of their judicial philosophy, which can also be important. So we need to take the election of judges as seriously as we take the election of city council members, of mayors, of district attorneys and city attorneys, of state senators and assemblymen, of governor, etc. Judges have an increasingly large impact on our lives, and so I think we have the obligation to take the time to do the research to learn about them and vote for them. That's one thing. That's number one. Number two, rather than judges being just assigned to the superior court in general, I think judges should be running for specific areas. So we should have a pool of judges running for, the probate court. We should have a pool of judges running for family law courts. We should have a pool of judges running for civil litigation. We have a pool of judges running for criminal litigation, or in criminal cases, so that we can look and see what are the qualifications of these judges vis-a-vis the area that they're running to be a judge in. Okay, so that way, especially those of us who practice in specialty areas. So like me, like you, we practice in trusts, estates, and probate. So we can look at those judges and get a sense as to whether they have, or which ones have the best skills, the best knowledge, the best experience for dealing in this arena. For lawyers and other parties, for example, mediators who deal in, say, family law. So again, they can look to see, do these judges have the background, the expertise, the knowledge to be dealing effectively in that arena, or which ones who are running do, right? And in that way, we can have judges who are much better prepared to deal with the caseloads. Now, the fact of the matter is we need more judges as well. That's a fiscal issue. But the fact of the matter is we pay for this one way or another. We could pay for more judges, or we pay for it in it takes longer and longer for these matters to be dealt with, which costs more legal fees. It costs more aggravation, lost time in attending hearings and having nothing decided and having to come back. All of these things at a cost to us. Now, you might argue, well, the cost is only it only impacts those people who have matters before the court, and so shouldn't they be the ones paying for it? Well, yes, that is a good point. I would argue, though, that having courts that run smoothly is part of the social and business climate in where we live. And so to the extent that courts do not run efficiently, it has a depressive effect on the ability for our society to operate and to operate well. And that discourages people from all kinds of things, whether it's starting businesses, coming to the state, et cetera, et cetera. So it's a problem not just for those of us who are routinely dealing with the courts, it's a problem for us as a society. And so I think the solution to, excuse me, too few judges and judges who don't have the proper background are, number one, hire more, or elect more judges, and two, focus the elections on by the skill set that the judge needs in order to be effective in a particular court. Now, there may have to be some reorganization. So maybe it's too narrow to have a judge who focuses only on probate. Maybe they need to focus on family law and probate so that they can do either, so that the courts have enough flexibility that, if a judge goes on vacation or is sick, they can still cover the caseloads. Okay. So, but I think those kinds of problems can be overcome. Nonetheless, we need to better be able to understand the qualifications of judges, so that when we commit to take the time to figuring out who are the best candidates, we know that they're going to be able to do the job for which they're being elected. Okay, so those are the first four issues that I've identified. The next issue as to how probate is broken is the costs are unnecessarily high. So what's interesting is, excuse me, the average estate in California is really not that big, even if the decedent owned a home. And so, the estate may be somewhere between 500,000, 750,000 to maybe a couple of $1 million. Now you say, well, that's a lot of money. Well, it is, but when you take into account that probably 50% or more of that is really the value of the house, so it's not a particularly complex estate. And the fact of the matter is that the reason it's so costly is the process is unnecessarily complex. So my friend Josh Yeager, I referred to him earlier. Josh and I have had a number of conversations about this. There have been some attempts to make the process easier. So, for example, here in California, we have something called a certificate of trust. And with a certificate of trust that's duly filled out, properly signed, witnessed by a notary, etc., that should allow a trust to be administrated even if the original trust document is lost. Here's the rub. Even though the form of that document is a statutory form, meaning it's a part of the law allowing for or creating certifications of trust, in my experience, every institution that uses that allows or that will accept certifications of trust wants it on their own form. Even if they get one that has all the same information in the same order, but it has some other institution's name on it, they will require one done on their own form. It really is crazy. And so, and that's just one little thing. So the paperwork that's necessary to transfer a bank account or a brokerage account from the decedent's name or the decedent's estate to the beneficiary, to the heir, every institution has a different form. Now, you would think these institutions would want to get together and create a uniform form, but so far that has not happened. Now, I have talked about this issue before, by way of talking about the Uniform Probate Code, which has been adopted by, I think, half or 2/3 of the states, at least parts of it. So this is a step in the right direction, but I think that there needs to be I don't know, a movement. That sounds so, 1960s. There needs to be effort on the part of financial, I can't think of the word, but financial companies to not just streamline the paperwork, but to make it so that, let's say you've got an estate where there's accounts held at 5 different financial institutions. So you're going to have to fill out 5 different sets of forms. It would be much more efficient to have a uniform form that all 5 institutions would accept. And so I think that while it wouldn't necessarily, people like me in point of fact, we get paid for doing this work. And so if there's 5 times the forms that, need to be filled out, well, that would seem like a good thing for us because we get paid, 5 times as much. The reality is I prefer to work efficiently. And I think as fiduciaries, we're required to work efficiently. So the fact that it might benefit us financially to fill out 5 different forms needs to be set behind us in the interest of our clients, and we need to be advocating among financial institutions for uniform forms. Not unlike, so for example, excuse me, in loans on personal property, there's in the Uniform Commercial Code, there are form UCC1, I believe it is. This is the uniform form used to create a security interest in personal property. It's used by virtually all lenders. So we need the equivalent in the probate realm, and it can be accomplished. It's going to take pressure, I think, on financial institutions to get them to do this. But that would be a large step toward taming some of these unnecessarily high costs. Other things, now California has a law for certain small estates or certain simple estates. I think that law needs to be looked at again because, again, with the huge increase in the values of homes, so many estates that seem, quite large, $1.5 million, $2 million, really still are pretty simple. And so we could probably expand that and simplify the administration process. And in so doing, we could bring down the costs, both the financial costs as well as the emotional and mental costs of going through this whole process. Finally, and this is the last of my 6 problems that that I've identified as being, the problems in probate here in California, and that is, I think there's a lack of wisdom. Now, I would argue this is a problem in our society in general. We seem not to prize wisdom the way it used to be. And the fact of the matter is, wisdom comes with time. There is no there is no substitute for it. Someone who's brand new to a profession, they may have a lot of information about it. They may have a lot of insight, maybe because they, the synapses in their brain are particularly attuned to what it is they're doing, but they're not going to have wisdom, because wisdom comes with having struggled with the various human problems that arise in a particular arena. And so I think we need to reevaluate the kind of focus on youth, that, or the not the focus. Let me rephrase that. The enamorization of youth that we see in certain functions in our society. And one of those is trust and probate matters. And the reason I say that is because while probate is primarily a financial process, because it's the collection of assets and debts, the payment of debts, and the distribution of assets, right, which are all monetary issues, there is a huge range of emotional issues that get involved. First of all, we have somebody who's died, and in a lot of cases, probably in the vast majority of cases, that's an actual loss. The people are not happy that the person has died. Now, they may be pleased that they're inheriting wealth, but that doesn't mean that they're glad that their loved one has died. And so the ability to deal with these human issues is very, very important. And it takes some experience and wisdom to do that. It's not sufficient to have empathy. Empathy is important, but it's not the only quality. And, as a chaplain who has helped numerous people through traumatic circumstances that include the death of their service member, abusive situations, spousal abuse, child abuse, all of these things, empathy was never enough. It just wasn't. So, I've recently had the opportunity to talk to a few people about my career in the Navy. As I talk about my profession, here in trusts and estates. And I remarked to them that my time as a chaplain has been incredibly important to what success I've had as a professional fiduciary. And one of the things I realized was my success as a chaplain came from the fact that I was older than almost everyone that I dealt with. So especially the vast majority of enlisted people, they were young enough to be my children when I became a chaplain, an active duty chaplain. And so when we sat down together, first of all, there was a sense that I had something to offer them. They were talking to someone they could trust, someone who had more life experience than them. So that, coupled with empathy, I think made a big difference. Another thing that made a big difference, and I'll never forget this, I had a young woman come in to see me who was very, very troubled. And I asked her to sit down, and I said, how can I help you? And she proceeded to tell me about the life that she had lived prior to joining the Navy. And it was horrendous. And she had been talking to a chaplain previously who had his time was up and he had left the island, and she was looking for a new chaplain to talk to. And the fact of the matter is, I had never experienced anything that she had experienced. And my sort of gut reaction was to say, well, I empathize with what you're saying. But the fact of the matter is, it wasn't that I didn't empathize with her. It's just, my empathy was very shallow because I had never had her experiences. And so I said to her, look, I said, I'm perfectly happy to talk to you about this. You just have to know that I haven't had these kind of experiences. And so my ability to understand them in a visceral sense really isn't there. And I said, but I'm absolutely here to listen. And if you want me to give you my thoughts, I will. But you just have to know, I have not lived a life like you've lived. And she looked at me and she said, "You're the chaplain that I want." Now, I think as a younger man, I wouldn't have had the courage to do that. I wouldn't have wanted to expose what I viewed as my shortcomings, but it was, in fact, the right thing to do. And I don't think I'm so different than other people. I think as young people, we are nervous about exposing our shortcomings, and that's why wisdom takes time to develop. And so we need to have people involved in probate and trust administration who have been around the track a few times, as I say about myself, and have had the opportunity to develop some wisdom. So those are my thoughts on the problems with the probate court and some of the things we can do to solve them. I invite your thoughts. Uh, really would love to engage with you on this. I just realized that's so weird. I have the wrong set of the wrong. I don't know why it's not. Let's see. Okay, there we go. It was the wrong train going on underneath us all this time. I really would like to hear your thoughts. I think these are real issues that we need to deal with, and for the good of our clients, for the good of the beneficiaries for whom we have responsibility or to whom we have responsibility, we really need to get this figured out. So I thank you very much for joining me today. And tomorrow at 10 a.m. Pacific time is my show, Business Lessons from the Military. That was what you were seeing the title crawl for. And my topic is optimize your resources. And I'm going to be talking about how the military has struggled with optimizing resources and the inter-service fights that have gone on with respect to that issue. So I think you'll find that pretty interesting. On Wednesday at 10 a.m. is my show, People Making Money. And I'm going to be talking about the types of relationships we need to be dealing with in the workplace. I've identified eight of them, okay? And I'm going to go through them. I think we have a narrower view of workplace relationships than we should. This is not about relationship etiquette. I'm actually going to be talking about that next week. This is about what kinds of relationships should we consciously be seeking out in the workplace in order to buoy our success. And then on Thursday will be a classic edition of Jiggers' Place. This is my every other week show. And I'm going to have a show that I did with my friend Anna Rook on, and she's going to be talking about healthy living writ large. I think you will find Anna to be extremely knowledgeable in this area. She and a partner started a company called Akasha Superfoods, but her knowledge and experience in this area, despite her young age, is incredibly deep, incredibly insightful, because she has been involved in this arena for a long, long time, since she was a teenager, seriously involved with it. So I think you will learn a lot from Anna. And that is on Thursday at 5 p.m. Pacific time. And then, of course, a week from today, we'll be back with the next edition of Trust and Estates Weekly. So once again, I thank you very much for joining me. Always great to have you live. And wishing, signing off as I always do, Marie, you are my bell. Courage.